Good day, Crime Talk aficionados. Guess what? The defense blinks in the Delphi homicide case. We're going to give you a quick Karen Reed trial update. The courtroom gets stormy in New York. So stormy they asked for a mistrial. Guess who arrived at Suzanne Morphew's memorial service? Chad Doerman? Well, he doesn't want to die. And I'm sure his three young sons thought the same thing before he executed all three of them. And then our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications, because for some reason, YouTube takes people off of the notifications. So hit that little bell. The algorithm likes it. You'll get notice. You watch it. We like it. It's a win-win for everybody. And guess what? That's right. We just recently went over 2 million downloads on our podcast. So you can check us out on any of your favorite podcasting apps if for some reason you can't watch us on YouTube, Facebook, Twitter, and Twitch, and Roku. So you have lots of options. So another 2 million on our podcast. Thank you all very much. All right, let's go ahead and get to the docket. So let's open the record for May 7th, 2024. And first on the docket, that's right, the defense blinked. Remember I talked about this just the other day where I said it's going to be very unlikely that all this pretrial motions work is going to get done in time. And then the judge in the case, Judge Francis C. Gull, was saying that, hey, we've got 2 weeks blocked out. That's all I was told about. Prosecution has 100 witnesses. The defense says they have 72 witnesses. No way were they going to get that done in 2 weeks. Simply was not going to happen. And I said this is kind of a little cat and mouse game. The question is who's going to blink first, the judge or the attorneys for Richard Allen? Well, guess what? It was the attorneys for Richard Allen. So the case has been delayed now until mid-October when it was originally set. Now, obviously, if you've been following this case, Allen faces 4 counts of murder in regards to the February 2017 deaths of Abby William and Libby German near the Monon High Bridge there in Delphi, Indiana. Well, at a hearing on Tuesday, the special judge, Francis C. Gull, granted the request of the defense to vacate a May 13th trial date. So the attorneys, Andrew Baldwin and Bradley Rossi, had previously requested a speedy trial. In fact, they demanded it. They wanted the case dismissed for violation of speedy trial rights. So guess what? That issue, poof, gone on any appeal if and when Mr. Allen is convicted. So those proceedings are now going to go begin in October, but they're going to use their efficient time. So the trial is now scheduled for a month, but there's going to use the time in May, specifically May 21 through 23rd, for pretrial motions issues. Now, Allen's defense attorneys had claimed that they had not had enough time to properly prepare their case and that the court had not granted the defense enough time to present their case during trial. As you may recall, the judge sent out an email to the prosecutor and the defense attorney saying, hey, I've looked at all of this alternate suspect evidence, and yeah, I don't think it comes in. And oh, by the way, we have 2 weeks set. You didn't tell me. So the judge kind of called the bluff of the attorneys, and like I said, they blinked. So the defense attorneys were worried that the prosecution, that has more than 100 witnesses, would dominate all of the proceedings, and the time was allotted, and then the defense indicated they wouldn't have time to present their case because the defense has 71 witnesses they intend to call. Now, obviously, that will get pared down prior to trial, but that was the excuse they needed to get the continuance. Now, Mr. Baldwin and Rossi wrote in their motion for the pretrial hearing that the logistical challenges for the trial, including an out-of-town jury, Mr. Allen's daily transportation to and from the prison where he is being held, would throw off the judge's aggressive timeline of only 2 weeks. Additionally, the state filed a motion in limine last week asking the court to bar the defense from presenting its alternate murder theory, the alternate suspect theories, that members of a local pagan group killed the girls in a ritualistic fashion during the proceedings. Now, the prosecution filed that motion after the judge said, hey, I don't think I'm going to allow this in. Hint, hint, wink, wink, nudge, nudge. Say no more, say no more. Mr. Prosecutor, how come you haven't filed this motion? Anyway, the prosecution says it's going to cause too much confusion and prejudice to the jury. They won't be able to figure out because juries are just a bunch of nincompoops, according to the prosecution. Anyway, the prosecution also sought to bar the defense from mentioning any cult or ritualistic killing or any other terms from the trial, as well as the names of several people previously linked to the case in one way or another. The defense also filed another motion to have Judge Gull disqualify herself from the case. And during a somewhat contentious hearing, Judge Gull told Mr. Razi that she couldn't understand why Allen's team couldn't defend their client during the time allotted for the trial. Mr. Razi argued that you don't know anything about this case, citing a lack of pretrial hearings to debate potential evidence. The defense previously asked the Supreme Court to remove Judge Gull, which the High Court declined to do so, and they filed an earlier motion asking for the judge to recuse herself as well. She also refused to do so. Now, Judge Gull attempted to remove Baldwin and Razi from the case early on, citing that they had leaked this evidence and expressed concerns about their ability to defend Mr. Allen in such a complex case, which apparently now is just so simple. But the Indiana Supreme Court reinstated the attorneys back on January 18th. Now, the prosecutor, Nick McClellan, asked the court to hold Baldwin and Razi in contempt, citing that they had leaked this evidence and sent out information in violation of a gag order. But Judge Gull said, although they were sloppy and incompetent in the handling of the evidence, it kind of fell short of being willful and intentional, so she didn't do that. And oh, that's right, all those comments were made before the gag order went into effect, so there was no violation. You would think anybody with first-year law school experience would be able to figure that out. Apparently, the prosecutor couldn't in this particular case. And the defense has also accused prosecutors for failing to turn over discovery in a timely manner. The attorneys are accusing investigators of lying or omitting information in order to implicate their client. So we knew things were going to get heated. I hope they get more heated, and maybe we'll even be able to see or hear the motions hearings to see why the judge believes the alternate suspect theory shouldn't be allowed. The alternate suspect theory is a little different because, remember, the prosecution has to prove identity. They have to prove that it was Mr. Allen that killed those two young girls, not someone who looked like him, not someone using his identity, but it was in fact him. And normally to bring in alternate theory suspects, you have to say, hey, these people over here did this crime, paganists, things like that, Odinists, and they were in the area and basically kind of fits their MO. So I believe the court will be somewhat correct as it relates to maybe not bringing in evidence of accusing specific people of a crime. However, it should be completely ripe for cross-examination as to the investigation and the extent to which the prosecutors either followed up on the whole Odinistic thing or they dismissed it. That is where the defense is going to make their hay, so to speak, when it comes to that. All right, we'll be watching, but a little disappointed in the defense, not going to deny it. They demanded speedy trial. And by God, if you're going to jump up and down, demand speedy trial, you better be ready to go. But I understand they have a bigger duty to their client, which is disappointing that we're not going to have a trial here starting in just a week or so. All right, next on the docket, a quick Miss Reed jury trial update. The Karen Reed trial. The jurors went to the courtroom on Monday for their second week of testimony. Last week, the jurors got to visit a scene where Miss Reed's boyfriend, former police officer John O'Keefe, was found dead. The jury trip included a stop at the Fairview Road home in Canton, Massachusetts, where O'Keefe was found dead, as well as the Waterfall Bar and Grill the last place where Mr. O'Keefe was seen alive. Now, Ms. Reed is charged with second-degree murder in the 2022 death of her former boyfriend. He was found in the snow outside a fellow Boston police officer's home, a guy by the name of Brian Albert. Now, prosecutors believe or allege or trying to prove that Ms. Reed hit Mr. O'Keefe with her SUV, while Reed says she has been framed in a wide-ranging cover-up. So I don't know, it must be an East Coast thing where everybody goes and visits the crime scene. Not really sure why that is taking place in all these trials lately, but it seems to be an East Coast thing, no doubt. Okay, so late last week, the defense cross-examined one of the paramedics in regards to their relationship with Mr. O'Keefe, with Caitlin Albert, Brian Albert's daughter, the guy who owned the house. So apparently the two attended high school together, and the attorney referenced the fact that McLaughlin and Caitlin Albert are friends on Facebook and both appear in photos for at least 2 beach trips. Now, Miss McLaughlin acknowledged she has known Caitlin for about 10 years, dating back to high school, but said they are not close friends. They do have a mutual friend and have gone on day trips together in the past, but McLaughlin said she has not discussed the case with her. Now, before the testimony on Monday, however, the defense attorney, David Yannetti, said new information came to light over the weekend showing that Miss McLaughlin perjured herself. The attorneys alleged that Miss McLaughlin and Caitlin Albert were more than just acquaintances, as they were both on the same high school track team, and new photos emerged showing them together, including one at a baby shower in June of 2021, about 8 months before O'Keefe's death. Now, the attorney said, quote, "It is very clear that Katie McLaughlin perjured herself," Mr. Yannetti argued. He asked for a ruling on the admissibility of the photos prior to Caitlin Albert's taking the stand, which prosecutors said is expected to happen sometime midweek. The judge, however, said she is going to address the issue either Monday or Tuesday. Now, really, oftentimes this means not a big deal. Is it perjury? Well, she may say, yeah, it was a baby shower, but it's casual. Is that really perjury? I don't know. But these are the type of things that juries can really hang their hat on and say, ooh, why are you being deceptive? Of course, if the judge allows it in. So we'll have to wait and see, but it kind of plays into the whole scenario where Miss Reed's attorneys are trying to say that the paramedics and the police officers all conspired to get Karen Reed. Let me know in the notes below, in the comments below, whether you think that they're doing just that. Next on the docket, things get stormy in New York. Almost caused a mistrial. So Stormy Daniels took the stand in the Donald Trump hush money trial, and the porn star testified about the alleged encounter that they had in a hotel room when they met originally at a celebrity golf tournament back in 2006. Now, the former president has denied any claims that he had a sexual relationship with Miss Daniels, and at a moment in the trial, prosecutors believe they did note that their trial could take at least another 2 weeks. Now, the judge did have to interject at one point, saying that Miss Stormy Daniels would be able to testify about sexual acts with the former president, but they asked her to keep it simple. And apparently the prosecutor said, well, we're not going to talk about descriptions of genitalia in any way. Anyway, so things got a little crazy. On cross-examination, the attorneys for the former president pressed Miss Daniels over making money off her story about being with Donald Trump, asked while refusing to pay Trump whether Miss Daniels had been making money off of the claims that she had sex with Donald Trump. Remember, Stormy Daniels owes Donald Trump some $300,000 for a lawsuit that she filed, and it was ultimately dismissed. Well, Ms. Daniels said if she's talking about the book, she said yes. And she's been doing this for more than a decade, bilking or making money off Donald Trump. Now, Ms. Daniels says she has not been paid for interviews in the United States. And when asked if she's been making money by claiming to have had sex with Donald Trump, Ms. Daniels counters that she has been making money by telling her story. Ms. Daniels also said that the story did make her a lot of money. It has come at a cost, however, Ms. Daniels said, and it's even cost her some money. And she didn't like it when asked on cross-examination whether the prosecutors had rehearsed her moment on the stand with the prosecutors, and that's clearly fair game, but Ms. Daniels apparently did not like that line of questioning. She was forced to answer the questions. But the defense basically tried to make her out to be a money-grabbing, exotic dancer who will do anything for a buck. Ms. Daniels was shown various tweets by the former president that Ms. Daniels also made fun of Mr. Donald Trump's looks as well, because he made fun of me first, she said. Now, on the screen in a tweet from Ms. Daniels where she wrote, "I don't owe him anything. I'll never give that orange turd a dime," referring to the fees owed in connection with the failed defamation lawsuit that she filed against the former president. And Ms. Daniels would not concede the fact that the former president won his case against her, and she simply said that he prevailed and that she was not found to have lost. And Ms. Daniels did state that she hates Donald Trump, certainly ripe for motive to fabricate indeed. At least that's what will be argued in the closing arguments. But Ms. Daniels says that she just wants Mr. Trump held accountable. Or, I'm sure if they could work out paying off that $300,000, I'm sure they could work something out. Anyway, the prosecutors in the case originally were allowed to go into great details of how she met the now former president. Now, this is all back in 2006, obviously before he was, in fact, the president. And at one point, the defense had to move for a mistrial based upon Miss Stormy Daniels' testimony. And everyone was told to slow down and shut up for a minute and only answer the question that was asked, because Miss Daniels embarked on a narrative. She seemed to have no recollection of how she ended up half undressed on the bed, something very different to the account that a consensual affair took place back in 2016, which she was trying to sell. So that was where the mistrial tried to come in. Now she's saying somehow maybe she was drugged or something along those lines, and which is totally different from her previous story that it was a consensual encounter. So that is huge for grounds for a mistrial, because you're basically now throwing in this taint that there was some sort of poison or something that was thrown in, or some sort of drug that was thrown in, and that's going to hurt the defense. And no one was expecting Ms. Daniels to go there. However, the judge denied the motion for mistrial because he said, well, the appropriate remedy here was simply to allow the defense to go into her change of story on cross-examination. I wish this had been televised. I really, really do. Because the judge acknowledged that Ms. Daniels was a little difficult to control, even for the prosecutors. And even the judge said, yeah, you got some good grounds for a mistrial, but he was not going to, the judge decided he was not going to grant it at this point. The judge did note that he thought that it was surprised that there weren't more objections from the defense. In fact, at one point, the court had to object because there was no objection coming from the defense, the judge noted. That's what they call it. The judge objected sua sponte, to protect the record, because even the judge thought that it was getting out of hand. So we'll have to wait and see what is going to happen. Definitely the three-ring circus we all thought it was going to be, but the prosecution was allowed to go into the fact that Ms. Daniels allegedly had unprotected sex, and oh yes, it apparently didn't last that long. So there you go, ladies and gentlemen. You can't make this stuff up. Next on the docket, let's get back to things a little more realistic, other than a former president running for president on trial for covering up a sexual tawdry affair. Geez, if that was against the law, I guess Bill Clinton may have to have something to worry about too, I guess. Anyway, guess who showed up at Suzanne Morphew's memorial service? That's right. Apparently, friends and family were a little shocked when Barry Morphew was described sneaking into an Indiana church for the murdered wife, Suzanne Morphew's memorial service held on Saturday. Now, this comes after a week after the autopsy report confirmed the cause of death for Suzanne Morphew to be a homicide. Now, there were plenty of guests arriving at the Trinity Baptist Church in Westgate, Indiana, which is close to a small town in Noblesville where Suzanne Morphew grew up. Barry Morphew, who was originally charged with Suzanne's murder before the case fell apart, attended the ceremony, as did daughters Mallory and Macy, who organized the event. People are speculating that Barry Morphew could be rearrested if investigators determine there is enough evidence to charge him with Suzanne's death. The pastor spoke, and a few family friends read some scripture. Apparently, it was very nice. Now, as you may recall, back in 2021, Barry Morphew was arrested and charged with the murder, but the case, like I said, fell apart. And now Barry Morphew is suing the county for $15 million over their alleged botched prosecution. Now, last year, Suzanne's skeletal remains were discovered lying in a remote field outside of Moffat, a small town 50 miles south of her home. Now, police have confirmed the cause of her death was, in fact, a homicide by undetermined means in the setting of some very heavy intoxicants that were found in her bones based upon the autopsy. The powerful tranquilizers were commonly used in veterinary medications, while one was used for a surgical anesthetic. So, although the case remains unsolved, the discovery of the animal tranquilizer drugs in Suzanne's bone echoes a theory advanced by the prosecution in arguments made in their pretrial hearings that Mr. Morphew had used the drugs to knock out his wife before killing her in a jealous rage. Like I said, the case is unsolved, but the Colorado Bureau investigation says that the announcement of the autopsy result in which they would continue to work the case. I don't know if it'll ever be solved, ladies and gentlemen. I really do not know if it will be solved. Next in the docket, Chad Doerman doesn't want to die. Unlike his kids, who probably had, thought the same thing when he executed all three of them. So the attorneys representing Chad Doerman, who is allegedly killed with killing his three sons last year, filed a motion to spare him from the death penalty. So back on April 30th, Chad Doerman's attorneys cited a 2021 law that bars the death penalty for individuals who are severely mentally ill at the time of the crime. Now, a hearing regarding Doerman's mental state is scheduled for August 5th, and his lawyers said that on Friday they are waiving his right to a speedy trial, at least until January 1st of 2025. Now, the motion claimed that two experts have assessed Mr. Doerman and determined that he was, in fact, mentally ill when he fatally shot his three sons. However, they could not agree on whether Doerman was aware that his actions were wrong at the time of the offense. Now, Mr. Doerman is set to stand trial for shooting his three sons, aged 3, 4, and 7. That's right, you heard that correctly, ladies and gentlemen. Shot his three kids, aged 3, 4, and 7, back in June of 2023. Now, Doerman allegedly carried out the execution-style murders in front of his wife and his stepdaughter, and he's also accused of planning his son's slaying for months before he actually did so. Now, the prosecutors allege that Mr. Doerman got off work early and walked around the home with a Bible mumbling, "Chad knows what's right." The boy's mother told Doerman that he was scaring her, to which Mr. Doerman responded that he was just kidding and just playing, before going to the master bedroom to lie down. Prosecutors allege the mother and one of the boys went into the bedroom with Doerman because they didn't want him to be alone. Shortly after that, Mr. Doerman allegedly got out of the bed, retrieved a rifle, and shot his 4-year-old son twice in the head. After allegedly killing his two sons, Mr. Doerman then snatched his 3-year-old son from his mother's arms and shot him in the head. Mr. Doerman then shot his children's mother in the hand. During the triple homicide, the stepdaughter picked up one of the surviving boys and tried to flee to a nearby firehouse. Doerman allegedly chased the stepdaughter down and demanded she put the boy down, to which she obliged. Doerman tried to shoot the boy, but the gun misfired and he fled. Now, prosecutors claim that Mr. Doerman eventually caught up with the boy and killed him. The stepdaughter fled on foot, to a neighbor's house who called the police. Before police responded to the scene, the boy's mother told a 911 dispatcher her babies had been shot. Police arrived, discovered 3 boys dead in the yard, while Mr. Doerman was found sitting next to the rifle on the porch. Now, Mr. Doerman is believed to have lined up his deceased sons in the yard before the police arrived. And in late March, Doerman changed his plea to not guilty by reason of insanity. And that plea came days after the judge ruled that his interrogation video of Mr. Doerman could not be shown at trial. He also ordered the statements taken before the initial questioning are inadmissible in court because they violated Mr. Doerman's rights under Miranda. So the judge determined that Doerman's rights were violated because the Detective Michael Ross, failed to read his Miranda rights verbatim. Police questioned Doerman for 3 hours after he invoked his right to counsel, which the judge also found is a violation of his rights. No motive has ever been determined in this particular case. I don't know, ladies and gentlemen. I was talking to another attorney the other day in regards to the death penalty and mentally ill people. And his position was that, hey, if someone is mentally ill and they're going around committing crime, isn't that the people that we really don't want on the street and that we should get rid of them? I thought that was a little over the top, but let me know what your thoughts are. You have people that are mentally ill. We're going to warehouse them for the rest of their lives. They're probably not going to get any better. They're going to be heavily medicated at great expense to the state. Is there some argument to be made for that? I don't know. Let me know in the comments. Certainly probably a little controversial. Next on the docket, our dumb criminal of the day. So an ex-con has been convicted of attacking his girlfriend with a, wait for it, this is a family show, ladies and gentlemen, so plug the kids' ears right now. That's right. The ex-con attacked his girlfriend with a pink dildo after she derided him as a, quote, limp dick, end quote, in need of some Viagra. Stephen Nurdin didn't exactly take too kindly to those berating comments, and he's ultimately pled no contest to a domestic battery charges stemming from the violent confrontation earlier in the year at a residence that he shared with the victim. So Mr. Nurdin was found guilty by the judge and sentenced to 8 months in jail. He was also fined $920 and to have no contact with the victim. Now, following his arrest, Mr. Nurdin was freed from custody after posting $2,500 bond. He, however, was rearrested for violating the terms of his pretrial release by contacting the victim via text messages, Facebook, Snapchat, and TikTok. Now, Mr. Nurdin, you know better. Any attorney is going to tell you, the judge is going to tell you, no contact means no contact. It doesn't mean that you contact them via Facebook, TikTok, whatever. Smoke signals, carrier pigeon, you can't have any contact. Anyway, Mr. Nurdin pled no contest to those violations, and he got 3 months in jail for that and a $1,000 fine, and that sentence will run concurrent with the battery on the pink dildo. Anyway, the victim said in this case that she had been arguing when she declared that he, Mr. Nurdin, needed some erectile dysfunction medication to address his sexual shortcomings. Mr. Nurdin became irate, retrieved the sex toy from the bedroom shelf, and shoved the sexual item into her mouth. He also punched her in the eye. It's unclear whether the sexual toy was in her mouth when he punched her in the eye, but I guess it really doesn't matter. Both seem just very, very wrong. Anyway, Mr. Nurdin, in his explanation to the court, does not recall ever wielding the sex toy. But Mr. Nurdin has been classified as a career offender because he was released from prison in 2023 after serving more than 13 years for armed robbery, aggravated assault, and being in possession of a firearm by a felon. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. Hope you enjoyed the show. We'll see you next time on Crime Talk, and remember, the Constitution matters.